Hi, Constitutional Kook Unincorporated here, speaking again on current events. And a biggie that's having some ramifications as we speak is the policy of the Trump administration, as you're well aware, to separate immigrant families and keep the children apart from the parents while it's being determined whether they have a right to be here. Now, that's caused such an uproar that even the Donald has done an about face on this. The policy hasn't fully turned 180 degrees, but it's on the way to doing it. And that's a good thing, number one, because American people do actually have some input on a rare occasion like this when they make themselves known, publicly and send a clear message that this is not the way we want to do business here. The real issue in these cases, however, and you can be damn sure the 9/0 farts aren't going to hear it, is how in the world is Trump acting using executive orders in an area that seems to me by the Constitution to be clearly committed to Congress under Article 1, not the President under Article 2. I would love to see a question like that get there, especially as hot of an issue as this is, but you know damn well that no bar member of the Supreme Court bar is going to dare to do that. I mean, that's as sure a ticket to going out of business as you can think. Before you're an attorney, you go somewhere else, you go to, podunk or whatever, and you settle down there and have a nice, quiet law career. It's just how it works. But think about that. The only reason he can do that, in my view, and this goes back to several things, and not surprisingly, you've heard me talk about it before, the bankruptcy of the United States and the Federal Reserve Act, which is 12 U.S.C. 95A and B, in which Congress delegated to the President authority unfettered discretion to declare states of emergency and allow Federal Reserve notes to be issued not in state judicial districts but in federal military venues. The same thing holds true for the bankruptcy of the United States, H.R. 192, about 3 days after that bastard Roosevelt took office. This is what they're doing, and the President is acting as Commander-in-Chief of the Armed Forces. That's the evil that we have to get to and throw it out once and for all. And it's an issue that's very, very rarely been before the Supreme Court. The obvious case is Youngstown Steel versus Sawyer, 343 U.S. 579. And the court actually ruled against Harry Truman, and his seizure of the sawmills. They actually ruled against him, but that's the first and only time. And what the hell, from my perspective, I can't see where in the world Youngstown Steel, Inc. had any status to be in that court to challenge it. Now, the government was too smart to make that argument because they could see that would lead to a much worse result, even worse than losing this case, which they did. But this type of thing just never gets there, and it's the sort of issue that we need to start getting there, and the sort of issue that from my 5 basic documents in my document packet that is available, trial court, and I've got an appellate court packet too, very modestly priced. You can send me an email at ccaspari@live.com for information on these. These are just the kind of issues we're setting up from day one in these trial courts, quote unquote, especially in the traffic courts. Now, in 4 decades, I have yet to have one of these bill of particulars answered. I've only recently, about the last 9 months or so, started to put motions to dismiss in. I had a big problem with that for a long time, but I came across some authority, especially from the Supreme Court, that I said, yeah, I think we can actually do this because we don't have any other way to go. Because we have no right, as people, you follow what I've been saying for all these videos, probably 300 of them now, then the Supreme Court has said no right to an appeal in any criminal case, no right to habeas corpus, the statutory version, with even actual innocence not being grounds for the issuance of the writ. And the appeals you have here, like in California, Article 6, Section 13 of the California Constitution, virtually mandates that the appeal court judges find any and all errors or omissions to be harmless errors. So given this background, and given the fact that the Supreme Court has also said we have a right to challenge jurisdiction at any time, and that we have the right to judicial process and trial by jury according to the course of the common law, then I came to the conclusion we should be putting in a motion, what I call a motion to dismiss, and I've got that accompanied in my document packet by a brief on the 14th Amendment, and that brief sets up a lot of these issues I've just been talking about, because that's where the exponential expansion of the president's war powers came into play. Because those of you who checked, and I'm going to challenge the viewers out there, if any of you can find a treaty that ended the war between the states signed by the government of the United States and the Confederate States of America, I'd love to see it. It doesn't exist. And if that's the case, then the powers that be behind the government, especially those of Wall Street banksters, probably are telling them 150 years later we're still in a state of war. And oh, by the way, the same thing still applies. You may have been aware of that recent summit meeting, between Trump and that idiot in North Korea. And there was talk before this event occurred that there may actually be a formal end to the Korean War declared at the time this meeting happened. As far as I know, that did not happen. And hell, we're 75 years, almost 80 years into that war, which was never a war, by the way. That was a UN police-keeping action. It was never a war. So this is the kind of crap we have to get around and start making these issues in the trial court. And this, if you could see the reactions to these bastards in their offices, in their chambers, when they see issues like this coming in there, even the most stupid of them has to understand how serious this is. And the good news for us is that most of them aren't going to understand it, and they won't know for sure whether we get to the 9/0 parts, and we can't beat them because these issues have never been there. And part of the court's key rules for their status and standing, I've talked about it frequently, Ashwander v. Tennessee Valley Authority, 297 U.S. 288, page 341. One of the key rules is the court says, and I quote, the court will not answer an issue of constitutional law in the advance of the necessity of deciding it. You don't ask, they're not going to answer. And they know damn well that the members of the Supreme Court Bar are not going to ask the questions we're raising. And they also know, with all the ignoramuses out there, and I'm not being insulting, they didn't teach me 50 years ago either, you don't learn a damn thing in their mandatory public education system. So how are we supposed to know that? Those are the ills I'm working very hard to correct and teach you how to do it. It really isn't that hard. Does it require time and effort on your part? You bet. It's not going to take you 4 decades like what it took me. You're going to have a lot of material to work with. It's a lot you're going to get hit with if you get my document packets. But it all comes together beautifully. And it's comparatively simple. In fact, these days, in certain of my legal briefs, I say, my gosh, the issues are so simple here. A room full of 4th graders are going to grasp it, let alone 12 members of a common law jury. That's how simple some of this is. It's mere mathematics in some cases. All you have to do is be able to count, which apparently they can't do in Congress, which is probably especially true given the fact that our national debt's, now, closing $3 trillion? Damn, quote-unquote dollars. We don't even know what the hell they are. But that said, this is the reason that this case would be important if we get the right kind of issues addressed with the immigration policies and who sets them and why. Now, if we're in a state of war, as we were from December 7th, 1941, that's a somewhat different state of affairs, and you can make the argument that the president might well have powers in that area. That's a very interesting subject matter for habeas corpus, which I'll be talking about another time, the court decision of that and what it really means. But that said, wartime is one thing. State of emergency is quite another. And for those of you that know your Constitution, Article 1, Section 9, Clause 2 says the writ of habeas corpus can't be suspended except in instances of rebellion or invasion. Doesn't say a damn word about a state of emergency. Who the hell cares about that? Especially emergencies that the New York banksters create, which is exactly what they did with the Wall Street crash of October 1929, and then they want to make the rest of us pay for it while they sit on their fat asses and profit from it. So we'll see how all this comes down later, but I went on a little bit longer than I should, and I'm going to revisit this case. I'm going to go over it. I haven't had a chance to thoroughly read this case yet, so I'll get back to you when I do and make some more points about that and be prepared to take questions and answers too. And by the way, you can submit questions to be answered the next time on videos at my email address, ccaspari@live.com, and I'll be happy to answer any questions that come in on that subject matter and a whole lot more. Thank you.